So, in the courtroom behind me last month, we covered one of the most controversial, complicated murder cases in South Carolina history, the Rose Petal murder. If you follow FITSNews.com, you're familiar with this case. We covered it gavel to gavel. It ended with guilty verdicts for Zach Hughes, the accused, now convicted killer in this, again, incredibly complicated case. The Rose Petal murder involves the killing of 41-year-old Christina Parcell, a vet tech in Greer, South Carolina. Now, that's where the simplicity associated with this case ended. And entering the drama were a whole host of characters tied to the murder, but also attendant allegations, including allegations related to child sex abuse materials or child porn. Now, those allegations tied directly to the victim in this case, which in the minds of many made this a justifiable homicide. Now, as the defense developed over the course of months leading up to the trial, no one knew exactly where Zach Hughes and his counsel were going to take this case. Would he take the stand? What sort of affirmative defense would he offer? Or would he simply argue that, yes, he committed the killing, but that it was justified? This week, I sat down with his two lawyers, Mark Moyer and Andy Mormon, to get their thoughts on the Rose Petal murder and the many challenges associated with defending Zach Hughes. Here is our conversation. All right, guys, I want to thank y'all for taking the time to sit down. Mark Moyer, Andy Mormon, the defense counsel for Zach Hughes in the Rose Petal murder trial. First question I got to ask you guys, did you ever think this case would blow up the way that it did? Yeah, it attracts so much attention from true crime aficionados all over the country. Was it surprising to see that level of attention?
I think anytime any case, gets as big as something like this, yeah, it is surprising. But, in retrospect, the people that we're dealing with here, if any case this would be it. I mean, Zach Hughes, just an amazing and fascinating and talented person. So if any case would get that way, it would be this one.
Andy?
I agree. We thought that there'd be some media attention. Just speaking for myself, I didn't think it would be this widely followed. So it was a surprise.
Yeah. Well, let's start with Zach Hughes, your client. Tell us about the man. You spent a lot of time with him. What are your impressions of Zach?
Incredibly talented, as we just said. He just right off the bat, you could tell he was just an extraordinary person. And you got to hear a lot about him in the trial and his background, the character that he was. He I would just say, just an incredibly smart and talented person.
Had a ton of family support, friends showed up on his behalf.
Yeah.
Andy, what are your thoughts on the guy?
He was, or is just, he was a pleasure to be around. He seemed to be always concerned with other people. He would ask us, without getting specifics, he'd ask us questions about our family, how our families were doing. He was not, a person in that circumstance can be self-absorbed because it's very stressful. But I found him to be utterly concerned with other people, which is a very unusual characteristic in a person, especially a person who's under that much stress. So just, as Mark said, extremely talented, bright, and just had a general concern for other people as opposed to himself.
I'm going to go ahead and go out on a limb and guess he's probably the most unexpected murder suspect you guys have ever defended. Is he the most unexpected, convicted killer you've ever seen, just based on that background and his?
It's unusual to represent someone like Zach who's charged with such serious crimes. Absolutely. It's funny when you've done something this long as we have. It's hard for things to be unexpected, but I would say that who Zach is, his background, it's very unusual to have someone like him charged with these types of crimes.
I'm also going to go out on a limb and guess that this was not the typical defense, that there were a lot of moving parts to this defense, a lot of things that were dependent on things that would happen during the trial, during pre-trial motions. But you guys were obviously dealt a very difficult hand very early. One of the first evidentiary hearings, DNA evidence was rolled out. There were camera footage. it was very clear pretty early that there was some connection between Zach and this crime. Did you guys feel at that first moment when you saw some of that initial evidence at that preliminary hearing, what are we up against?
So, anytime you defend somebody, whether we were both former prosecutors, and whether you're a prosecutor or a defense attorney, if the case is in a trial posture, part of the preparation is to be prepared for what may happen. And so you're constantly, you're trying to determine, first you review the discovery to make sure you understand what the evidence is very well. Then you're trying to determine the most effective ways to mount whatever defense may be applicable to the facts and the law. And so in coming up with that defense, you're constantly gaming out scenarios as to what may happen at trial so that the defense stays alive. And so at least the way, and I think Mark agrees, the way we think about it is we're never sort of enamored with how strong a particular case is. We're more focused on if we're in a trial posture, what's the defense? How do we effectively get that defense in front of the jury? And giving ourselves as many different opportunities as possible, depending on what happens at
Like
trial.
a chessboard.
It is, and it's, going back to this word unexpected, a trial is a very fluid thing. So no matter how much you prepare for trial, you can never be completely certain as to what's going to happen. That's why you want to prepare as much as possible to lessen the chances of the unexpected happening. But bottom line, going into this defense, as we would any other case, we're constantly trying to determine what is the defense, how do we effectively convey the defense, and how do we keep it alive, depending on how things unfold at trial.
And that was certainly in this case an evolving process. And I wanted to ask you guys, before we get into the trial and some of the things that happened during the trial that kind of maybe caused you to shift on the fly, how did the defense approach evolve leading up to the trial? Were there strategies that you considered, then abandoned? Were there debate between the two of you over what tack you were going to take? How did your defense evolve leading up to the trial?
Yeah.
I mean, it was just many discussions.
Mm-hmm.
I mean, I couldn't even hundreds of hours, meeting after meeting, both with the client and with the two of us. Just
Zach was involved in that process.
as any client would be.
Sure.
As any client would be. So,
Suggesting approaches or?
rather not get into specifics.
Sure,
yeah.
no, that's fine.
But when a lawyer is made aware of what the evidence the state's going to use is, and when the lawyer has an opportunity to understand what the facts are from the client's perspective, then it's the lawyer's job to fashion defenses that are viable and persuasive. And so, as you said earlier, this case is a very unusual case. The facts are extraordinary, and so that combination required sort of out of the box thinking. And so we just a lot of long discussions and just a lot of very very profound discussions.
Your thoughts?
Yeah. Yeah, I'm not sure I have anything to add to what Andy just said. Yeah, it was, No.
I mean, the other thing that was important is we've tried many cases between the two of us, and so one of the things we said repeatedly is that this type of case with the type of client we had, we were grateful that we had had that much experience because, to your point earlier, there were a lot of things that happened that we had to pivot on. There were a lot of things that happened that required us to not necessarily to change the overall strategy, but to adapt to the evolving circumstances in the trial. So the countless hours we put into preparing for trial and the meetings, I think we both feel like that preparation paid off the best it possibly could, and we needed that going into the environment that was the trial.
Well, talking about one of those sort of wrinkles you guys were throwing, Mark, I remember you and I ran into each other outside the detention center September 2023. You were kind enough to give me some of your time after one of the hearings there. But those charges, the conspiracy harassment charges against Zach Hughes that linked him to this wild card in the case, John Melo. Let me ask you guys about John Melo. I guess the first big question I was asked, did you ever think about calling him to the stand?
Well, in any case like this, you have to keep your options as wide as possible. So, going into our trial preparation, you always wonder, well, could it come down to this? That we would call him, or would he be called by the state? And so we certainly prepared in that, but the way our defense kind of evolved, the way the case kind of evolved, as you could see, it never really became necessary to have to do that. So yeah, at the end of the day, no, we just decided not to, and we don't think we needed to.
Mm-hmm. And
I don't have much to add. Anytime you go into a trial, you identify the universe of possible witnesses, and you're always doing sort of the cost-benefit analysis. Is it better for our case to call this witness, or is it worse for our case to call this witness? And so Mr. Melo was run through that filter as every other potential witness would have been going into trial and during the trial.
surprised the state didn't call him or try to call him?
No, not really. Just based on, as you said, what you know about him and kind of the wild card that is there. It wasn't really a big surprise.
A lot of folks have referred to him as the cousin Eddie of this trial relating to the Murdaugh trial, and cousin Eddie being the witness that neither side ended up wanting to call. They feel like John Melo was sort of that type of witness, but given his integral involvement, his friendship with Zach Hughes, clearly they exchanged numerous messages, which we now know, based on your client's own testimony, were tied to at least, if not a conspiracy, certainly collaboration and cooperation related to this crime. How does somebody like Melo get the kind of hold that he had over Zach Hughes? Because you look at someone like Zach Hughes, and again, I'm just somebody who doesn't know him as well as you do, obviously. Don't know Melo. But how does someone like that get a hold of someone so, as you mentioned, just insanely talented, gifted? You're talking about what a giving person he is. His rationale for committing this crime was, in essence, he's trying to help someone. How does somebody like that get mixed up with someone like John Melo?
I think I would dispute the premise of the question just a little bit as far as getting a hold of him. Mm-hmm. As you heard, there was testimony in the trial about a friendship, but as Zach testified, what he did was not based on any kind of hold that John Melo had on him. He did what he did because he believed it was the right thing to do. Mm-hmm. And it was not because of anything any type of manipulation or anything that John Melo may have tried to get him to do.
You don't think John Melo spun him up?
No, I don't. I mean, he got information from John Melo, as you heard in the trial. But Zach did what he did, as he testified to, because he believed it was the right thing to do, not because he was manipulated.
Yeah, do you agree with that?
Totally. And to Mark's point, I think the testimony showed that Zach's testimony showed that he was very deliberate in trying to understand what was happening. He was given documents. Mr. Melo, the evidence was that Melo provided Zach with information, but he didn't take, and even our pleading said this, Zach did not take the information that Mr. Melo provided at face value. And he wanted to understand what was happening. He wanted to be right. And ultimately he was right as far as the concerns he had for the child.
I thought that was his most compelling moment on the stand when he made that declaration, and I was right. I thought that was his most compelling moment. Let me ask you guys about this, about what he was right about, the elephant in that courtroom for the entire 2 weeks. And I want to start at the end of the process and kind of work our way back. I'm sure you guys have read some of the coverage since the trial about what jurors were thinking. I think you said you hadn't talked to any of them yourselves, but you've seen accounts in the media. The jurors were upset that they didn't get the full story. They were upset that they didn't know the why. Let me ask you guys about this. Were you surprised that it didn't come in at any point, the child sex abuse material, child porn allegations against the victim, in this case, Christina Parcell? Mark, were you surprised it didn't come in?
Well, you have to, when you go into a trial like this, you have to be prepared for everything, for whether it comes in or doesn't. Obviously, as you heard in the trial, this was an important part of our case. The defense of others, defense of another, which is why Zach acted as he did. So, we were trying to prepare for any eventuality that came about. So we were trying to prepare for whether it did or didn't. We felt it was important. We felt that it was an important part of our case, and that it should be something for the jury to consider. You just never know, I think, going into a trial, what evidence is going to come in or not. So,
Do you feel there were moments, and either one of you please answer this, did you feel there were moments during the trial where the door was opened for that evidence to come in?
That was one of the evolutions that was most surprising. When we were putting together the defense, and we filed the pleading on Tuesday morning, that was very comprehensive as to what the defense was going to be, what the facts were, we were going to prove, and how the law applied. Going into the trial, we were prepared to make that argument. I'll just speak for myself. I did not believe that there would be additional bases for admissibility that would come up during the trial. And so I was surprised that during the trial, there were at least, I would argue, two separate times where the door was open, where we didn't expect that to happen, where this evidence arguably became even more admissible.
And you guys moved very quickly when that happened as well.
We did.
And you were surprised Judge Fan kept it out at that point?
We argued very aggressively during the trial that it was admissible. We believe to this day that it was admissible, but Judge Fan disagreed. The court disagreed, and that happens with frequency. So we believed it was admissible, and the court disagreed.
I talked to an attorney earlier this week about this case and about the forthcoming appeals process. And they used the term baked in the cake. And I thought that was an interesting turn of a phrase. And I said, what do you mean by that? I said, well, he's going to get a new trial based on that evidence not coming in. As you guys, and first of all, let me ask you this. Are you guys going to handle the appeal?
So we have filed the notices of appeal.
The notice, correct?
Yeah, we have filed that to preserve Zach's right to appeal. We're still working through that process as to what our involvement is going to be.
Yes.
So we don't know yet.
And a lot of times it's handled by different attorneys, and certainly everyone understands that. But thinking about that appeals process and that comment, how significant do you think that decision will be as a Zach Hughes appeal of this conviction starts to take shape? Will it be the central thrust of that, or?
It'll be an important thrust. It'll be important. It's hard to say in the absence of actually putting together the brief as to what's going to be the most important, but I think it's undoubtedly a very important part of the basis for the appeal.
Mm-hmm. Mark, what are your thoughts on the appeal process?
Yeah, as Andy just said, that is going to be one of the main features of the appeal. We believe there are several issues, and so we're just going into it optimistic that we will succeed.
And you guys preserved a lot for the record in this case. There was a ton of proffered testimony, evidence. Is that, again, as you were working through that part of the case, conceptualizing that, a lot of that was obviously stuff you thought the jury would hear, based on not only the door opening a few times during the trial, but that'll obviously be key to the appeals process.
Yeah, absolutely. As you know, the appellate courts can't go outside of the record. Mm-hmm. And so during this trial, we just had to be very, very aware of and very diligent about trying to make sure the record was as complete as possible. So we had a number of witnesses, as you saw, that we were unable to get in front of the jury. And so whenever we had the chance and the opportunity arose, that we just had to take that opportunity to to, as you said, proffer that testimony and to summarize to the court as best we could what that witness would have testified about. So that was a very important part of the case.
And you guys both done federal work as well. Do you see the potential for, again, if the state appeals route dries up, if you can't keep that alive, do you see a potential habeas here?
I think it's too early to tell.
Mm-hmm.
Honestly, I think there might be a better understanding once the issues firm up on appeal and the briefs are constructed. But I think it's probably too early to tell right now.
Let me ask you guys about your client taking the stand. One of the things we've heard from folks who were close to the deliberations, they felt he was off-putting. They felt he was a bit too antiseptic about this crime, which again, if you look at it, he's admitted it, and it is an incredibly graphic crime. The testimony of the forensic examiner, I was in court that day, it was chilling to hear her very dispassionately go through the list of those individual wounds. But let me ask you this, as it relates to Zach's decision, was that something he wanted to do? Was it something you told him he should do? Certainly he received plenty of guidance from the court before he made that decision. But looking back on that decision, should he have taken the stand? Anything he could have done differently, better to sway that jury away from the verdict it eventually landed on? Mark?
Well, Will, as you heard my opening statement, I stated that Zach has been waiting a long time, 3 years, to get in front of that jury and to tell what happened. Obviously, we can't go into the back and forth that we had with Zach, attorney-client privilege, but Zach wanted to tell the truth. And, you know, as lawyers, you're your client's agent. And so when it came down to it, at the end of the day, he wanted to get in front of that jury and tell the truth, to tell what exactly happened and why it happened.
He wasn't able to, though, in a lot of circumstances. In fact, I think one of the things he said that was also very compelling was, you know, Your Honor, I've sworn an oath to tell the truth. You're not letting me do that.
He said that. The one of the components of this I think is overlooked. I do think it's very important. Is that on Tuesday when we began our case, the trial court indicated that we would not be allowed to assert a defense of others' defense, and that we were very aggressive in the way we litigated that. But up until Thursday morning, the last day of trial, when Zach had completed his direct examination, there was still an element of the law that would have allowed the jury, we believe, to account for why Zach did it. And specifically, one of the things we argued was that the definition of malice, there are many definitions, but one of the definitions is the intentional doing of a wrongful act without just cause or excuse. And so if you notice in Mark's opening statement, just cause or excuse was what he said, which was still viable under the concept of malice, even though we had lost the defense of others concept. So even with hours, just a few hours before closing arguments, that was language we believed would remain in the jury instruction. We believe that was black letter law. And so I think that's very important. I think one perception is that, well, the trial court ruled that we weren't going to get into the defense of others. So you sort of, why continue this concept of just cause or you know, trying to explain? And again, one thing that's overlooked is up until about 2 hours, the last day of trial, 2 hours before the closing arguments, the jury could have considered that idea in the concept or in the context of malice. And so up until almost the very end, and the trial court disagreed and amended the definition of malice to remove that language over our objection. He removed just cause or excuse. But up until the very end, it was evolving.
What was the motive for that decision to leave that language out?
I think
I'd have to ask the court. But
well, I think the trial court put it on the record. And again, I would defer to the trial court's understanding. But my understanding was that the trial court believed that if we didn't get a defense of others instruction, then we couldn't get a just cause or excuse instruction. And our response to that was, they're different. The concept is different in different contexts. So for the defense of others, that's a defense.
Yeah.
Whereas in the context of malice, frame of mind, that undermines the state's ability to prove an essential element.
Mm.
And so
one's offense from your end, one's defense. Right. Okay.
But again, the trial court disagreed, and so going into closing arguments, there was very little left available from a legal standpoint for us to explain to the jury that they had that they could account for his frame of mind.
Now let's give Prosecutor Walt Wilkins some credit. Seasoned prosecutor. He had an opportunity on cross-examination of Zach Hughes to really dive into some things. He made a calculated decision to ask one question. And a lot of folks have looked at that and said, well, what was he thinking? But that also limited you guys in what you could get into coming back to your witness. Were you surprised he did that? And did that kind of handcuff you guys a little bit at the last minute?
Well, I guess you'd have to ask the solicitor himself about his strategy, but it was probably a very smart strategic decision, quite truthfully. Mm-hmm. Zach is, as we've been saying, is an extremely intelligent person, and we believe an extremely compelling person. So from a strategic standpoint, it eliminated the possibility of Zach being able to answer questions and to fill in some gaps to the jury. So, again, it probably was a pretty wise decision at the end of the day.
Now, Zach did get a few references in, obviously earned a contempt citation as a result, but, and I want to ask you guys about this, because one of the other things we heard from the jury deliberations and sources familiar with those, a few times, and one time in particular, a door was left open between the jury room and the courtroom, and some of the conversation that was taking place about these very matters that they were told, and in this case, not told about, some of that was overheard. Is that the kind of thing that could potentially compromise this verdict?
To be determined. That particular issue, I think there's potentially an argument that would cut in favor of Zach. But in just reading your coverage, again, we haven't communicated with any jurors, but in reading your coverage, it appears that the jury took the court's instructions very seriously. Mm-hmm. And so, assuming that to be the case, and we have reason to believe it is, any communication they may have heard in the court that was inconsistent with the judge's instructions, I think they probably would have followed the judge's instructions. So, bottom line, I don't think we know. But it does appear again that they followed the court's instructions pretty literally.
There was a moment during deliberations, a note came back, one of several, but this one, when I saw it and heard it, felt like you guys had a real chance. When the jury asked the judge to, again, reissue to them that definition of malice. When you guys got that note, saw that note, what went through your minds? Mark, what did you think when you heard that?
Well, as we've been talking about here, and as you know, malice was the linchpin of this case. So when the question came back about malice, well, yeah, absolutely. We were like, all right, the jury is focusing on what they should be focusing on. So,
you're encouraged.
Yeah, I would say so. Obviously, you never know in which direction they're taking that thought, that argument amongst themselves. But yeah, it was encouraging to know the jury was following and focusing on what was the essence of this case. And as we've been discussing, unfortunately, we were not able to develop that theory as much as we were hoping to do so throughout the trial. So I think that may be, who knows, but that could be why the case ended up not going to, the way we wanted it to go.
Andy, what were your thoughts when you saw that note come back?
I mean, it was It was a good development. We talked about at counsel table, having tried as many cases, you just don't know what a jury's going to do. So it's hard to extrapolate at that time what that really means. But it was a good development, and my closing argument was structured almost exclusively on that concept. And so it was a good development.
Obviously, this case, the appeal, you guys have made it clear this is going to be, the notice has been filed. There's some significantly fruitful grounds that could be pursued here on an appeal, but there are also other criminal cases tied to the Rose Petal murder. We've got the charges against Brad Post, the fiance of the victim, Christina Parcell, numerous charges against him related to the CSAM child porn found on the site. Those are being, we think, prosecuted by the Attorney General. It's been a little while. They kept that on ice, perhaps, to perhaps not impact this trial. Is that the thinking?
You'd have to ask them.
Yeah.
Well, we've asked the AG. They've been very quiet about this case.
Yeah. It's and there's nothing wrong with this, nothing unethical about this at all. And like I said, we were prosecutors. Oftentimes prosecutors will go into cases and trials thinking about how they can maximize credibility of witnesses they intend to call. And when you have a cooperator who's charged with crimes, oftentimes it's more advantageous for that person to testify in an environment where there's been no promises made as to how his or her cases will be resolved, as opposed to quickly resolving the case and then having to deal with what the negotiation was. So nothing wrong with that. That happens all the time. And again, I'm not even sure that was the reason. You'd have to ask the AG's office.
So we've got that trial forthcoming at some point, we believe, or a plea. Then there's also the charges against John Melo. He was already charged heading into the trial with harassment and conspiracy, and he is also now facing charges directly related to Christina Parcell's murder. So there will be a prosecution there. I sense that one will go to trial based on what we know of John Melo. You guys can track those cases closely as it relates to potential appeal and maybe having to retry this case if the appeal goes your way. You can follow those cases closely.
Yeah.
What are you looking for as those cases unfold?
Great question. It's just, we'd only be speculating to know what, or it'd just be pure speculation. But yeah, we just want to see what, who testifies, what do they testify about? What is Melo's defense going to be? How's that impact us? Same with Brad Post. What else are we going to learn about what was going on? And who knows? Maybe nothing. But trials take odd turns and twists. So we could learn a lot more. Yeah.
Andy?
So I agree with Mark. We're going to follow it. There's one thing we've learned about this case is things can change dramatically from one day to the next. So with Melo being arrested so recently on the new charges, I would imagine that would, as a practical matter, push back the timetable on everything. So it may be a while before we really understand what how Melo's case is going to be resolved.
Last question for you guys. This thing circles back around. If an appellate court finds that the probative value of the CSAM child porn should have outweighed the prejudice to your client, if they determine that he does indeed deserve a new trial, you guys back in it? And if you are, is there anything you learned from this first trial that you would change your tactics or strategy moving forward in a potential retrial?
Well, I guess to be determined a little bit about whether we'll be involved. I'll speak for myself. I hope so. Obviously, I'm extremely invested in this case. I was a prosecutor for 29 years. This case came to me about a week after I retired from the prosecutor's office and opened my practice. So this case has been my practice. Okay, I'm just hugely invested in it, just from a personal standpoint. So yes, I hope so, and we'll see. What have I learned? That's a great question too. I mean, I think I still need some more time to reflect on everything. So I'm not sure how to answer that question.
So I agree with Mark. We care about Zach. I care about Zach. I hope that I'm able to continue to work on the case. Right now, thinking about round 2 and a trial is so far away. Zach has been convicted. He's been sentenced, and so that's a serious development, and we don't take anything for granted. So our concern right now with Zach is making sure that again, we filed the notices of appeal, making sure that the appeal is done with excellence and done well, whether it's going to be us or someone else, and then go from there. As far as what I've learned, to Mark's point, it's a little early. One of the things that I think lawyers have to do when they represent clients is remain objective and be able to the best they can, put their emotions on one side and their thinking on the other. And
Don't know how y'all do it.
well, this is one of the cases. I think both of us typically do that pretty well. This is one of the cases that's been very hard to do because of the amount of time we spent with Zach, our ability to get to know Zach and his family. So if I could say sort of I've learned anything, it's that lawyers aren't robots, and sometimes it's hard to keep that those dimensions separate. That's not bad, because to your point, in a case like this, if you didn't have some emotions, if you didn't have some affection for the client, if you didn't respect the family, you wouldn't be human.
Guys, I really appreciate it. Before we go, anything you want to tell folks about Zach, about how he's doing in the aftermath of all this, about what his perspective on these matters as all these cases and the appeal and the other criminal prosecutions move forward? Have you talked to him? Where's his head on all this?
I think he's strong. To begin with, he's strong. I think he I don't think I think he believes what he did was right. I don't think that's changed in the least bit. And I believe that his concern still primarily is for others and not himself, even now.
Yeah, he's an extremely, as Andy said, he's strong. He's an extremely disciplined person in mind and body. And so, no, we did not see a change in him. Again, as Andy said, he believed what he did was right. And he's unwavering in that. And he is prepared to face the future, however it unfolds.
I think this conversation has shown that it could unfold a lot of different ways over the coming months and years. Guys, I can't thank y'all enough for taking the time to sit down. Really appreciate it. And certainly whatever folks think of this case and their views on the protagonists in this drama, I think everyone agrees you guys did a remarkable and commendable job advocating on behalf of your clients. So we appreciate you sharing that with our audience.
Thank you very much.
Will. Appreciate it.
Thanks, guys.